next to speak is Noura Erakat, talking about the subject called We Charge Nakba, Colonial Genocide of the Palestinian People. Ms. Erakat, can you hear me?
Yeah, you could.
Are you with us, Noura?
Yes, yes.
Yes, thank you. Your time's up. Go on.
Okay. I just want to acknowledge my comrade, Mr. Haidar Eid, Professor Eid. That was quite moving. That's incalculable loss. And may we, in these collective efforts, vindicate those losses with our liberation. My name is Noura Erakat. I'm a legal scholar and a professor at Rutgers University, and I am here in my capacity as an expert in international law. In the time I have, I will address specifically how the genocide of the Palestinian people in Gaza is quintessentially colonial in nature and constitutes the cruelest phase of our Nakba. I will conclude on the implications this has for the rest of the world. The jury should consider that Israel, together with its allies, has sought to a confounding Nakba peace. Israel's precedents for such Nakba peace took place between 1947 and 1949, when Zionist militias and later Israel's conventional army conducted military operations that collectively targeted Palestinians in the name of a defensive operation. In Plan Dalet, that plan included the destruction of villages by siege, quote, and conducting a search inside of it, and in the event of resistance, the armed forces must be wiped out and the population expelled outside of the borders of the state, end quote. Framed as defensive, this program of collective punishment aimed at Palestinian civilians and civilian villages resulted in the expulsion of 80% of Palestine's native people and the destruction of 500 villages. No one was punished or has been punished since then. The brazenness of Israel's current campaign is predicated on the normalization of the Nakba. The international community accepted Israel's claim for legal exception in 1948. UN membership on the return of Palestinian refugees, but failed to do so. As Professor Ardiyamsis has written, the international community treated, quote, the new state of Israel as a fait accompli, despite emerging through clear violations of the terms of Resolution 181, as well as international humanitarian and human rights law, and transformed Palestinian refugees into a humanitarian issue whose fate would be determined through political negotiations. The past is the present. More, the Nakba committed in the shadows of the drafting of the Genocide Convention to the newly drafted convention, and Israel, viewed as genocide's canonical victims and reparations, could not be conceived as its first accused genocidaire. The international community further normalized the Nakba in the following decades, particularly UN Security Council Resolution 242 and the crystallized diplomatic consensus for a two-state solution predicated on the removal and forced exile of native Palestinians. Today, Israel is continuing that tradition of an exception, insisting that its military campaign is justifiably pursued for the purpose of ethnic cleansing. And though it may seem genocidal, they tell us, it is necessary for its sustainable and long-term security. This logic says that the proximity of Gaza, inhabited by 2.3 million Palestinians, 2/3 of whom are refugees seeking to return to their original homes, makes the entirety of Gaza and its population, civilian and otherwise, a threat that needs to be removed or permanently subdued, regardless of whether or not they actually pose a military threat. Accordingly, Israel has insisted that to achieve its military purpose of sustainable self-defense, it should not be subject to red lines of combat and is within its sovereign right to remove the Palestinian population and prevent their return. They are not the first colonial power to make such claims. Unfortunately, however, the Genocide Convention, together with ICJ jurisprudence, do not adequately address this colonial violence. Genocide was legislated as its own unique crime that aimed to exterminate a people based on their immutable character precisely because of that character. The final treaty defined genocide in law as comprising two overarching elements: the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such, and the commission of specific acts to achieve that goal. What the final text of the treaty did not include in its definition of genocide, however, is also significant. Destruction of a group of people was limited to their physical destruction on purpose. It excluded the destruction of a group's political, economic, cultural, and linguistic existence. As such, the final treaty effectively excised colonialism and its constitutive violence from the scope of the international crime of genocide. The Genocide Convention failed to connect a group's biological life to the land upon which they live, thus obscuring how forced removal from land can be tantamount to a group's destruction even if its members survive. Perhaps most significantly, the convention explicitly does not apply to the destruction of a political group, neglecting the way groups with shared political affiliation can overlap with those who share immutable characteristics, particularly during wars of national liberation and struggles against racist regimes. The treaty condemned the destruction of a people, but not the kind perpetrated by the most powerful states. The way the convention has been interpreted by the ICJ also implies that the specific intent to destroy a group should be understood so narrowly as to exclude the more protracted and systematic destruction of a group across time that has been common throughout settler colonial history. In Bosnia and Herzegovina versus Serbia and Montenegro, for example, the court was not convinced that the mass killings of Bosnians happened with such specific intent. The ICJ discounted the systematic destruction of archives, libraries, monuments, and mosques because the convention only punished physical destruction. On nearly every count, the ICJ drew a very thin line between ethnic cleansing, committed for the purpose of forced removal, and genocide, committed for the purpose of destruction. Ultimately, the ICJ established a high threshold to demonstrate intent, thus reinforcing Western prerogatives to absolve themselves of their crimes. The long-standing normalization of the Nakba, together with the Genocide Convention's colonial blind spots and ICJ jurisprudence that further limits its application, makes it questionable whether the ICJ in its current form can ever really vindicate Palestinians. But failure to properly evolve jurisprudential standards and to adequately contend with genocidal violence in a settler colonial context will say more about the ICJ's relevance than it will about whether Israel has committed genocide. At this point, it is not what the ICJ says about Palestine, but what Palestine has to say about the ICJ and international law more generally. And it is already saying so much. In the past 2 years, the United States, in its global role as superpower, has had to systematically attack the post-World War II legal order to allow Israel to continue its carnage. Together, the Biden and Trump administrations have made a mockery of the UN Security Council by using its veto 6 times to undermine a multilateral resolution to genocide. They admonished and disregarded the ICJ's provisional measures to prevent genocide, criticized the ICJ ruling on Israel's unlawful presence in the West Bank and Gaza, and imposed on sanctions on anyone aiding the ICC case. Rather than resist the United States, France questioned the ICC's jurisdiction and allowed Netanyahu to fly over its airspace, while Hungary and Poland openly defied the court's arrest warrants. Meanwhile, the U.S. has withdrawn from the Paris Climate Accords, the World Health Organization, and now UNESCO, in its bid to continue undermining an international system. It waged a genocide and simultaneously disemboweled international law and the institutions meant to prevent and punish it. As President Gustavo Petro put it aptly, Gaza is a rehearsal for the future, a future where capital sovereignty supplants national sovereignty, where states are led by corporate boards rather than elected governments, where political democracy is attenuated to allow markets to grow unencumbered by the demands for healthcare, labor rights, education, and dignity. We are being primed and desensitized to the violence necessary to forge this dismal future. Palestine is the epicenter of this struggle, where world powers are turning Gaza into a graveyard of international law, as well as basic norms of humanity, including empathy and solidarity. Esteemed jurors, we must defeat these forces in Palestine and save a future for everyone worthy of our children. I urge you to recognize the colonial nature of Israel's campaign, as well as the legal and political limitations that have made calling one of the worst colonial genocides of our time by its name. Thank you.
And Ms. Noura Erakat is still with us, so I will ask if the jury and the penny have questions for her.
Are there any questions from the jury for Noura Erakat? We're returning to the segment where Noura was speaking. Haida has left, so just Noura. Sami, you have a question?
My question pertains to not just what the ICJ could declare. When we identify this, what would be internationally, talking about international law, sanctions, I wanted to understand more about states that can go after systems and after countries such as the Zionist regime, like what the Houthis or the Yemenis or others. Do they have the right to intervene into, militarily speaking, into countries that have already been identified as genocidal states? What are the limits by which other people could also, other than countries? What would be the international law point of view?
Thanks, Sami. Noura.
Thank you for that question. I want to start by saying, absolutely, third parties have a right to intervene. Let me give you the basis on which that can be done, and then the impediments. So the primary basis on which that can be done is collective, is the duty to prevent genocide, by which these states, all by observing that they have this duty, have then the right to intervene in order to prevent genocide. That's one. The second basis that it could be done is based on collective self-defense, which is, one of the only two exceptions to the prohibition on the use of force in the UN Charter, that they can, in order to defend themselves against what's happening in the region, can also mobilize that right. The third basis upon which they can intervene is based on the recognition of the Palestinians and their leadership as nascent sovereigns who are asking for third-party intervention. So there is not a lack of legal bases upon which states can mobilize in order to intervene in many ways, including militarily, to protect the Palestinians from this ongoing genocide. The impediments to this are a few. The first is the fact that we have been told over and over by Western powers that we don't know if there's a genocide unless there's a legal ruling, hence this emphasis on both how the U.S. has been trying to disembowel the International Court of Justice, together with the fact how the Court of Justice and the Genocide Convention itself has colonial blind spots, as well as an erasure of Nakba. So this compounds that challenge. That said, I think it's very clear that this legal argument about what the ICJ says or is going to say is a deflection. It's a political deflection. No other cases have been contingent on an ICJ finding in order to find genocide, especially because the convention is meant to prevent, not merely to punish, this crime. In the US's case in particular, before the Biden administration stepped down, Secretary of State Anthony Blinken declared that there was a genocide of the Masalit ethnic tribe in the Darfur region of the Sudan without a judicial finding. And when pressed on this topic, the ambassador on international crimes for the United States deflected and basically said that they could find that there was genocide in the Sudan, but that in Palestine they wanted to wait for the court, making very explicit this double standard, which then finally is the greatest challenge: whether states have the right to mobilize and to intervene and have the legal basis to do so. This is a matter of political will, and the pressure placed upon them, probably outright threats as well, as we've seen threats being imposed by the United States, and actual punishment in the form of sanctions, for example, on the ICC, including the prosecutor Karim Khan, Special Rapporteur Francesca Albanese, and 3 Palestinian human rights organizations who were the first 3 to submit to the court in November 2023 charges of apartheid and genocide, PCHR, Al-Haq and Al-Mizan. These are the political barriers which we as an international community are gathered in order to overcome.